in perpetuity, not until some final point after. I mean, my hope is that eventually we get to sites we can walk away from, and somebody can come and put a housing development, a resort, whatever on the site, and it's safe. And if you've got to be doing that kind of maintenance forever, it's better than having to have a water treatment plant forever, but it's still encumbering that land for all future generations, and that's of concern. But the less of that you have to do, the better.
Jeff, I don't want any competition.
What's that?
I said I don't want any competition.
That's what this is all about. I knew it.
Other questions? All right.
Thank you again.
Very much. Others who wish to testify in opposition to these amended?
Good afternoon, Senator Saviello, Representative Welsh, members of the committee. My name is Jenn Grey, not Jenny Grey. Yeah. Welcome to my childhood experience. 5 Jennifers in my class. That's why I have two N's in my name. And I also want to congratulate Grandpa Campbell. Thank you for your listening to all the testimony this morning and this afternoon. Maine Audubon does have concerns about the changes proposed in LD 750. Overall, we think the rules have improved and there's been good progress, but there remain a number of important weaknesses that need to be addressed before we could support them. And I have a list in my testimony of the weaknesses that we've identified. But I've been asked as a member of our team to talk about some of the legal questions that have been looming past sessions in this session. You've received a letter from Assistant Attorney General Lynette Pissner recently around some of the questions regarding the statute versus the 91 rules. And I wanted to bring to your attention that Attorney Roach submitted to the committee an additional letter with the comments that he submitted last year to the committee on this important issue. I think that all of the attorneys agree that in general statute does trump the rules. However, Attorney Roach also points out that because the statute clearly says the 1991 rules remain in effect until the new rules are adopted, the 1991 rules remain in effect. And I personally, and as an attorney, I think that his assessment is appropriate. Having said that, I think we can agree that smart lawyers could make a lot of money arguing about this, and that this issue is ripe for a lawsuit. Should an applicant file a metallic mineral mining application prior to the legislature's approval of new rules, surely someone would submit a legal challenge. And it would seem unlikely that a prudent applicant would take such a risk and invest a significant sum of money on an application that would be extremely likely to be subject to multiple lawsuits. Because first you would have a battle over what standards would apply before you even get to the battle about whether the applicant has met the standards. So that's just ripe for money and time and delay. But having said that we don't think this is a reason to delay approval of the rules forever. However, it is reason for the committee not to feel rushed or the legislature to feel rushed, and that they shouldn't take the time you need to make sure that the rules are sufficiently strong to protect the public health and safety, the environment, and to make sure that taxpayers aren't left holding the tab. So please take that time. We ask that you continue to work the rules. We particularly do not, you see there's a long list of weaknesses that we think need to be strengthened, but we particularly oppose this idea of sending the rules back to DEP and never again having an opportunity for public comment or legislative oversight. So I thank you for your consideration.
Questions? Yes.
Yes.
Senator.
In the response from your attorney or Mr. Fitzgerald's attorney, I just want to make it clear that both the chairs requested information on that letter, not just Senator Saviello. Okay. And it appears that he is in conflict with what her statement is, because she made it pretty clear in the letter that the old rules, because of the synchronicity of the lack of passing something, had not been applicable. He's saying that doesn't matter. Is that correct?
Well, in my opinion, because it actually, I'm not sure that the level of detail and legislative history was explored in writing her letter. It seems to us that the fact that this committee so thoroughly talked about what you were intending to do with that clause and it's in statute, that has greater weight. So it's not only that it's in a rule, but it's actually that section is in the statute.
But they were a significant part of this conversation 3 years ago. So they're building on this. So I think they have a pretty good idea what the history was. You
And
don't
again,
think they did?
my also point is that I think there are lots of room for disagreement and right for lawsuit.
I trust my general.
Representative Duchesne.
Thank you very much, Madam Chair. A little more in this synchronicity of what I remember of Linda Pisn's letter, and I'm doing this off the top of my head, was not only is there a conflict between the rule and statute, but we didn't fix it in the last legislature, and time has passed. If the legislature at that time deemed that it was really important to fix the conflict, it would have. It would have needed 2/3 vote to get it done over a veto, but the legislature failed to act. A lot of the testimony we're getting today is we should fail to act again and boot it down the road even further. The longer that gap gets, doesn't the court get to decide the legislature could have, should have acted, and didn't?
Well, I think that there's a valid and strong argument that because the statute says these rules remain in effect until the legislature adopts new rules, that sits there for as long until the legislature approves new rules. So I think, again, either way, the point is that there's going to be lots of arguments about what the law court would ultimately rule. But in the meantime, you guys should focus on making sure the rules don't feel rushed and get them right.
Representative Martin.
Thank you very much. I would say that it's the last thing that we've done is rush anything right now since January.
Right.
But I will say this, that the rules that were adopted were based on a law that frankly doesn't exist anymore. So, that's the other side of that question that really needs to be reviewed. But I will say that you have some points that you have made on the front of the page that I agree we need to resolve those.
Right.
And they are confusing, and there's no question that I'm sure this committee will do that.
Thank you.
Thank you.
Other questions? Thank you very much.
Thank you.